So, we need to talk about a seismic 9-0 unanimous decision that just came down from the Supreme Court, a ruling with massive nationwide implications for how federal courts across the country are going to handle a major constitutional question going forward. But here is the twist that is raising eyebrows across the entire legal community. Even after that powerful, unanimous message from the highest court in the land, expansion of the ruling was ultimately denied. And because of that, what we have is a decision that is both incredibly powerful in what it establishes and at the same time deliberately limited in how far it reaches. This case has now created real tension in how lower courts are applying these critical constitutional protections. Today, we are going to break down exactly what this ruling says, why the expansion was denied, and what it actually means for you, for the legal system, and for cases that are going to be working their way through courts all across this country for years to come. Before we get into it, if you want to support this type of content and never miss an update on cases like this, make sure to hit that subscribe button and turn on notifications. It really does help push this kind of content to more people who need it. And a quick thank you to attorneys on retainer, and when it comes to self-defense legal protection, they are backed by an actual law firm and focused on giving members real maximum value. Whether you carry every day or just want peace of mind, check them out using the link in the description. Now let us get into the case at the center of all of this, Barnes versus Felix. This story starts on an ordinary day with a routine traffic stop, the kind that happens thousands of times a day across this country. Officer Roberto Felix pulled over a man named Ashtian Barnes. The stop was connected to suspected toll violations involving a rental car. Nothing dramatic, nothing that would suggest what was about to happen next. Officer Felix ordered Barnes to exit the vehicle. Barnes opened the car door, appearing to comply. Then, in what can only be described as a horrible and tragic mistake, he suddenly tried to drive away. In a split-second reaction, Officer Felix jumped onto the running board of the moving vehicle as it began to pull away. While holding on, he drew his firearm and fired 2 shots at Barnes, fatally wounding him. The entire encounter from the initial stop to the final shot lasted just a few minutes. A toll violation, a man dead, and a constitutional question that would ultimately travel all the way to the highest court in the land. Barnes's mother, Janice Hughes Barnes, filed a lawsuit on behalf of her son's estate. She alleged that Officer Felix violated her son's Fourth Amendment rights by using excessive deadly force during the stop and attempted seizure. That lawsuit set off a chain of legal events that exposed a serious and longstanding problem in how federal courts across the country were handling these kinds of cases. And it is a problem that goes far deeper than just one officer, one family, or one tragic afternoon on the side of the road. To understand why this case matters so much, you need to understand the legal landscape that existed before the Supreme Court stepped in. For years, different federal circuits had been applying different tests and different standards for evaluating when an officer's use of force crosses the constitutional line, and that inconsistency had created real problems for everyone: plaintiffs, officers, and the courts trying to apply the law. Your Fourth Amendment rights might look very different depending on whether you lived in Texas or California, in New York or Florida. That is not how the Constitution is supposed to work. The whole point of having a Supreme Court is to ensure the Constitution means the same thing everywhere in this country, regardless of geography. The Fifth Circuit, which covers Texas, Louisiana, and Mississippi, had been using what they called the moment of threat rule. Under this approach, courts were supposed to look only at the precise instant when the officer perceived an immediate threat and decided to use deadly force. Everything that happened before that specific moment, how the stop was initiated, the severity of the underlying offense, any earlier warnings given, any opportunities for de-escalation, was largely off-limits from the analysis. The district court originally applied this framework and granted summary judgment in favor of Officer Felix. The Fifth Circuit affirmed that outcome on appeal, sticking strictly to that narrow time frame, and that is what ultimately brought the case before the Supreme Court, because this kind of rigid, time-limited approach was clearly in conflict with long-standing Fourth Amendment precedent from other circuits. On May 15, 2025, the Supreme Court issued a 9-0 unanimous decision written by Justice Elena Kagan, and the core holding was straightforward but powerful. When evaluating whether a law enforcement officer used excessive force during a stop or arrest, courts must analyze the claim under the Fourth Amendment's objective reasonableness standard. That means asking what a reasonable officer on the scene would have done, considering the totality of the circumstances, the full picture, the complete sequence of events, not just the final frozen second before the trigger was pulled. The court rejected the moment of threat doctrine entirely. They made clear that this reasonableness inquiry has no artificial time limit. Yes, the situation at the exact moment force is used will often matter most. That is the decision under review, after all. But earlier events and earlier context can absolutely matter. Factors like the severity of the underlying crime, in this case, essentially a toll violation, the officer's own behavior during the encounter, any warnings given or not given, and the suspect's conduct, including attempts to flee, all play a legitimate role in the analysis. The court reminded everyone that these cases are, in its own words, fact-bound and messy. Judges have to work through the full picture rather than applying a rigid rule that ignores important context that shaped the entire encounter from the beginning. This was not a minor clarification. This was the Supreme Court standing up for a complete constitutional standard and telling every federal court in the country that they had been doing it wrong. Several circuits had been using variations of this narrow approach, and by rejecting it unanimously, the court sent a clear and unambiguous message. You cannot short-circuit the Fourth Amendment analysis by artificially cutting off relevant facts that came before the final seconds of a confrontation. The decision reinforced the foundational precedent from Graham v. Connor, the case that has guided excessive force claims for decades, and it restored the full scope of the inquiry that the Constitution actually demands. Because of that 9-0 ruling, the Supreme Court vacated the Fifth Circuit's earlier decision and sent the case back down for reconsideration under the corrected standard. The lower court was instructed clearly, apply the proper totality of the circumstances test without the artificial time restriction. At this point, many observers expected the case to get a genuine fresh look. After all, the Supreme Court had spoken with one voice and clarified the correct legal framework in no uncertain terms. The expectation was real reconsideration. What happened instead is where this story takes a deeply interesting turn. The Fifth Circuit panel did not hold new oral arguments. They did not call for full additional briefing on the merits. Instead, after a relatively quick process involving short letter briefs from both sides, they issued a new opinion. And in that new opinion, they once again ruled in favor of Officer Felix, this time claiming to apply the totality of the circumstances as directed by the Supreme Court. This second decision has sparked significant debate across the legal community. The Fifth Circuit focused heavily on the fact that Barnes had attempted to flee in a moving vehicle. They reasoned that any vehicle flight, even from a minor traffic or toll stop, creates an immediate and deadly risk to officers and the public alike. According to their analysis, a reasonable officer could justifiably fear that allowing a suspect to drive away would lead to a dangerous pursuit that could injure or kill innocent people. They emphasized the split-second nature of the decision Officer Felix faced once Barnes started moving with the officer partially on the vehicle, and they concluded that even when considering the broader context of the stop, the officer's actions were still objectively reasonable under the Fourth Amendment. Critics of this approach argue that while the Fifth Circuit technically acknowledged the totality standard, they placed overwhelming weight on the final moments of the encounter and the general dangers of vehicle flight, which is essentially what they did before, just with slightly different language wrapped around it. The minor nature of the underlying toll violation, the way the stop was conducted, the absence of any indication Barnes was a violent criminal, and any realistic opportunities for de-escalation were pushed to the margins of the analysis rather than genuinely weighed against the threat. Supporters of the ruling respond that vehicle flight cases are uniquely dangerous, that split-second decisions deserve significant deference, and that the law should not be used to second-guess officers who face genuine physical peril in real time. This is where the true constitutional tension lives. Does the Supreme Court's 9-0 ruling allow lower courts to reach the same outcome through a different route focused on the risk of vehicle flight? Or did the Fifth Circuit find a way to honor the letter of the ruling while effectively undermining its spirit? And if lower courts can simply repackage their reasoning and arrive at the same destinations they were already reaching, what did that unanimous ruling actually accomplish? Because of those unresolved concerns, Barnes's attorneys filed a new petition for certiorari with the Supreme Court, asking the justices to grant review a second time and clarify whether the Fifth Circuit had genuinely and faithfully applied the totality standard on remand, or had instead substituted a risk-of-flight shortcut for the moment-of-threat shortcut that had already been rejected. The petition argued powerfully that allowing this kind of analysis to stand would undermine the nationwide implications of the original unanimous ruling and send a signal to lower courts that creative repackaging is an acceptable substitute for actual compliance. The case was distributed for the Supreme Court's conference. The government waived its right to file a response. And then the order list came out, and the Supreme Court officially denied the petition for certiorari. They declined to take up Barnes v. Felix for a second time. No further opinion, no expanded guidance. The expansion was denied. Now, it is absolutely critical to understand exactly what that denial means and what it does not mean. A denial of certiorari is not a ruling on the merits. The Supreme Court is not declaring that the Fifth Circuit got everything right. They are making a procedural choice not to intervene again at this stage. The court receives thousands of petitions every term and can only hear a fraction of them. Sometimes they deny review even when genuinely interesting and unresolved questions remain, particularly when they believe the original opinion already provided sufficient direction, or when they want to allow the lower courts more time to develop the doctrine through real cases with real facts. But the practical effect in this specific case is final. Officer Felix retains qualified immunity. The lawsuit brought by Janice Hughes Barnes on behalf of her son's estate is over. Within the Fifth Circuit, this risk-of-flight reasoning, now dressed in the language of totality, will influence how future excessive force cases involving vehicle escapes are decided in Texas, Louisiana, and Mississippi. That matters enormously for the people who live and work in those states. So what does all of this actually mean going forward beyond this one case and this one family? For law enforcement, the picture is genuinely mixed. Officers in most situations still have significant qualified immunity protection, particularly when they face sudden vehicle flight. But they also know that courts must now examine the entire sequence of events, not just the final moment. Training matters more than ever. Body camera footage of the full encounter, documentation of the complete stop, and clear communication from the outset of an interaction have all taken on greater legal importance. Small details from the beginning of a stop can now be legally significant in ways they might not have been under the old narrow framework. For citizens, and particularly for those who carry firearms and understand that interactions with law enforcement carry real weight, this case is a sobering reminder. The Fourth Amendment demands objective reasonableness based on all the facts. But the legal system that implements that standard is messy, imperfect, and produces outcomes that do not always feel like justice to the people most affected. If you are ever in a situation where you are being pulled over, the practical advice has not changed. Comply first, contest it through proper legal channels afterward. The moment you try to flee, you have handed the government enormous justification for whatever happens next. Ashtian Barnes paid the ultimate price for that decision, and his family has spent years in courts trying to account for it. Looking at the broader constitutional picture, the Supreme Court's decision to stop short, to deny expansion and leave the harder questions unanswered, was a deliberate institutional choice, and it is one that can be understood even if it is not entirely satisfying. The justices may have wanted to give lower courts time to work through the details of applying the totality standard before locking in more specific rules. Forcing agreement on every application across 9 justices might have fractured the consensus that gave the original decision its unanimous power. And there is a genuine tradition in constitutional law of letting principles develop organically through case-by-case adjudication before the Supreme Court steps back in to consolidate and refine. But the harder truth is that leaving these questions unresolved has real costs. Those costs are not borne equally. They fall heaviest on ordinary individuals whose cases will be decided by lower court judges working without clear guidance, in circuits that may read the same precedent in very different ways. The law looks like it is settled because the Supreme Court issued a unanimous ruling. But on the ground, in the circuits, in actual courtrooms, it is anything but settled. We are almost certainly looking at another cycle in this area of law. Lower courts will diverge on how much weight vehicle flight should receive in a totality analysis. New circuit splits will develop. Petitions will eventually bring one of those splits back to the Supreme Court. And the court will step in again, probably with a more specific, rule-like holding that provides the detailed guidance they chose not to give this time. That is how constitutional doctrine actually develops in this country. It is slow, it is messy, and in the meantime, real people pay the price for the uncertainty. There are actually 3 possible scenarios worth thinking through as you watch this area of law develop. The first and most optimistic scenario is that the lower courts do their job responsibly. They take the principle the Supreme Court gave them, apply it faithfully and honestly to the wide range of factual situations that come before them, and over time a coherent, consistent body of doctrine emerges. Consensus develops around how the factors should be weighed and what kinds of context truly change the analysis. In this scenario, the delegation succeeds and the system works as intended. The second scenario is the cycle scenario. Lower courts do not reach consensus. Different circuits go different directions. New splits emerge. The Supreme Court eventually has to come back in, armed with richer factual records from more varied cases, and issue more specific guidance. This is historically the most common pattern in constitutional law, and it is not necessarily a bad one. It just takes time and produces real uncertainty in the interim. The third and most concerning scenario is one where lower courts essentially pay lip service to the totality standard while continuing to reach outcomes they would have reached before. If that happens, the unanimous ruling becomes a kind of formalistic requirement. Language courts have to include, rather than a genuine constraint on how they analyze these cases. That outcome would represent a real erosion of what the Supreme Court accomplished, and it would take another strong intervention to reverse. Which of these 3 paths we are actually on will become clear through the decisions issued in the months and years ahead. That is why staying informed and watching closely matters so much. What that means for you, watching this right now, is to keep watching. Pay attention not just to what the Supreme Court says, but to how the lower courts respond. The real story of Barnes v. Felix is still being written, one circuit decision at a time, and as it develops, we will be right here breaking it down. If you found this breakdown useful, drop a comment below. Do you think the Fifth Circuit genuinely followed the spirit of that 9-0 ruling, or did they find a way around it? Should the Supreme Court have stepped back in to provide more clarity? Your thoughts matter, and they shape future content. As always, thank you for watching and for your continued support. Stay safe, stay informed, and I will see you in the next one.